For those who are just joining us, hello everybody. My name is TJ Scott. I'm a Minnesota estate planning attorney with the law office of Timothy J. Scott. Thank you for joining us to learn this information here. What are you hoping to learn here today? And if people want to share with me, I would really appreciate it. If there's some particular question that you were hoping to get information on here tonight, this is a good time to share that with me today. Maybe you're wondering if an online or do-it-yourself will is going to be sufficient, if it's going to take care of your family in the way that you hope that your family would be taken care of. Or maybe you wrote your estate plan 20 years ago or 30 years ago when the kids were young, and you want to know if that estate plan is outdated or if it's still going to be effective, if it's still going to take care of things in the way that you want things to be taken care of. Or maybe you haven't written an estate planning, you just want to have a better understanding of estate planning, or you want to have a better understanding of a plan that you did write in the past, and maybe you worked with an attorney who kind of just glossed over things or moved through things really quickly and didn't give you a good understanding of what that estate plan was. Whatever the situation, I hope that you'll share with me in the chat or the Q&A exactly what it is that you're hoping to learn here today. See, we have a little bit of a quiet audience here tonight, and that's okay. Sometimes that happens too. I have lots of great information to share with you. I can assure you of that. I want you to know as well that you are in the right place here tonight. Like I say, we're going to be talking about estate planning. We're going to be talking about it maybe from a Catholic perspective in a number of different aspects. But even if you're not Catholic, even if you haven't written an estate plan yet or don't have an immediate plan to write an estate plan, I want you to know that you're in the right place here. You are in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you've tried to do an online or do it yourself will, but you're just not sure how it's going to work. And you're also in the right place if you're nervous about how much this is going to cost. Trust me, I understand. I get that question a lot. And we're going to talk about it. I'm going to specifically address it. In fact, exactly how much you can expect to pay for a well-written estate plan if you work with an attorney. And I see somebody offering, thank you for sharing, that they want to avoid probate for their daughter. We're going to talk about probate tonight, and we're going to talk about why, for my clients, it's usually the best plan is to avoid probate and to avoid the added time and complexity and cost that probate promises if your estate has to go through probate. So thank you very much for sharing that. We will talk specifically about why we want to avoid probate and specific ways that we can avoid probate. Just a quick reality check here, though. Estate plan, estate planning isn't really about us. It's really about the people that we love. And this was something that was really made clear to my wife and I when we were recently updating our estate plan, is that we weren't going to see monetary benefits from our estate plan. It's not like starting a business or something like that or investing in something. It is kind of an investment, but it's an investment for the people that we love, that we want things to be easy for them. We want them to be taken care of, and we want them to know that we took care of the responsibilities that we had during our lifetime so that they would be well cared for when we could no longer be with them. And that's the truth, is our loved ones are going to know whether or not we lived up to our promise to take care of it for them. And we can. We absolutely can. And again, I'm going to be sharing some great ways that you can move forward and get a great estate plan written after our presentation here today. So we're going to cover a lot of things today. Like I say, I have a lot of great information that I want to share with you. We're going to talk about first, what is an estate plan? And we're going to talk about minor children and guardianship for minor children. If you guys don't mind, if you don't mind sharing with me, I say you guys, if you don't mind sharing with me, let me ask you, how many people here have minor children that they are planning for? Kids under the age of 18 that they're concerned about, and that if something happens to them, they want those kids under the age of 18 to be cared for. And if you wouldn't mind sharing with me, I'd really appreciate knowing how many people have minor children. So I'll keep watching over here. If you see me turning this way, there's a reason for it. That's where chat is for me. Also going to talk about healthcare decisions and what kinds of healthcare decisions we want made for us, what kinds of healthcare decisions, or who we want making healthcare decisions for us, how we can document that legally. We're also going to talk about uh, that from a specifically Catholic perspective, that if you're Catholic, what kinds of healthcare decisions does the church teach you ought to have made on your behalf? We're going to talk about decisions after death. And in particular, again, we're going to talk about what the church teaches about what should happen with our remains after we pass away. This is really something important to get right, and especially if you are like so many people right now, having a family or with maybe some kids that are not really following in the faith anymore, and maybe don't really have a strong backing in the faith, but you want to make sure that things are done in the right way after you pass away. This is something that's really important to document and make sure that you have right. We're also going to talk about who has a right to receive from your estate. Whether you've written an estate plan or not, there are some people who have a right to receive from your estate, and we're going to talk about what that looks like and how you can make changes to that. We're also going to talk about avoiding court and conflict, and that's true in both a guardianship and conservatorship perspective, people who can make healthcare decisions for you and decisions about your person, as well as decisions about your finances and your assets, but also from that probate perspective, that after we pass away, we want to make sure that things are taken care of so that they don't have to go through court, they don't have to get complicated. We're going to be talking about things with somewhat of a Catholic lens here tonight, with a particular eye to things like the Great Commandment. Great commandments. Love God with your heart, soul, and mind, and love your neighbor as yourself. We're going to talk about things with a perspective of respect for life, that we believe that life has value, and human life, our life, has significant value. And we want to make sure that we're preserving that in the right way and using that life in the right way. We're also going to talk about our responsibilities, that what the church teaches us as our responsibility to God, a responsibility to our family, and a responsibility to our community. And we're going to talk about estate planning in a way that we're using our estate plan to foster a growth in virtue. And in particular, maybe talking about the Beatitudes and how they enter into the growth of virtue, and what we can really promote through our estate plan. And also striving for sainthood, striving to be living holy lives, and helping people to live saintly lives as well. But before we talk about those things, and before we talk in that lens, I want to tell you just a little bit more about myself. This is a picture of me and my family. My wife's name is Tobin. We have 5 kids, and we live in Bloomington, Minnesota. We homeschool the 3 oldest kids. The 2 youngest are not yet in school, so they're just a kind of added bonus here at home. We have a rising 7th grader, rising 5th grader, and a rising 3rd grader. We're parishioners at Holy Family Catholic Church in St. Louis Park. And when I'm not doing estate planning, I am with my family. That's where I spend my time, all my time. A little bit about how I started in the practice of estate planning. I graduated from the University of St. Thomas School of Law in 2012. I graduated magna cum laude, which means I was pretty near the top of my class. I was on law review, and the day after I commenced from law school on May 12th, my son was born. That's Ben. He's our 13-year-old, our rising 7th grader. And when Ben was born, it really helped to clarify some of the wishes that I had about my life and about my practice and about the things that I wanted to do and where I wanted to spend my time. That I wanted to focus on serving people and focus on giving people value. And I was able to find a great way to do that in a small estate planning law firm, working under an attorney who had been practicing estate planning for something like 35 years. I learned how to write really great documents. And I also learned that a plan doesn't stop at the end of the documents. That once those documents are written, that's great, but there's a little bit more to it. There's more that I need to provide as a counselor, as your attorney, who's going to help you with the process. That it really requires a lifetime of guidance. So first, what is an estate plan? And this is my simple definition of an estate plan. An estate plan is a plan for your person, your assets, and those you care for in the case that you become incapacitated or for when you pass away. So, 2 different situations. Sometimes we don't become incapacitated before we pass away, but more and more we're hearing about people who have Alzheimer's or people who are in a coma. people who have gotten to a place where they're not able to make decisions for themselves anymore, and they're relying on people to make those decisions for them. And then all of us, it's just a reality. Here's your memento mori. We are all going to pass away to someday. And we need a plan for our person, for our assets, and for the people that we love for when that day comes. So let me ask you, if anyone's willing to share with me in the chat or the Q&A, I know that we have kind of a quiet audience here tonight, and that's okay. If anyone wants to share with me, do you have an estate plan? Have you done estate planning before? And again, I'm not seeing a lot of response, and that's okay. I think we just have kind of a quiet audience here tonight. But I am very glad that you're here with me. I'm seeing it. I'm so okay. So I'm seeing some people responding. I'm seeing some no's and some yeses, and some no's just a will. I would consider a will a part of an estate plan. That really, an estate plan is like an umbrella. It includes things like a will, it includes things like a healthcare directive and a power of attorney, memorial instructions, which are details about what happens with our body after we're gone. It includes things like beneficiary designations. If we have minor kids, it includes things like guardianship nominations. And it may include a trust. And a trust is a tool that we're going to talk about later. It's a great tool for avoiding probate, but it's not necessary for everybody. And we'll talk about, when you might want to have a trust in place and when you maybe don't need to have a trust in place. But it is a great tool for avoiding probate that we'll talk about in a little bit. But first, I want to talk about the guardianship nomination piece. That again, I don't know how many of you have minor children that are here with me today, but if you have minor children, or if somebody in your family has minor children, maybe your own child or a neighbor or something like that, guardianship is really important to get correct. And the reason is that if you don't have guardianship in place, the decision maker for where the kids are going to go is in the hands of the judge. That if you haven't vocalized, if you haven't told the court, if you haven't told people what you want to have happen in a legal document for guardianship of your kids, if something happens to you and your spouse or the parent of your child, the default is a judge is going to decide what's in the best interests of the child. And the reality is, you know what's in the best interests of the children. A judge is not going to know. A judge is just going to have to use their best judgment for what's in the best interests of the kids. And if that means that Uncle Larry is the perfect person they think to take the kids, or Aunt Susan is the right person to take the kids, that's just what they're going to do. And if it's kind of out of your hands, if it's gotten to that point. And that's true for long-term guardianship. Long-term guardianship is who gets to raise the kids until the age of 18. Um, Oh, this is really nice. Okay. So I have somebody sharing with me here that they're a Texas attorney not well versed in estate planning, but in particularly interested in providing advice to fellow Catholic parishioners. That's amazing. Thank you for sharing that background with me. And certainly, I'm going to have some good information for you here tonight. If you're interested in connecting after the presentation here today, I would love to connect with you as well and tell you, give you some guidance and kind of point you in the right direction for how you can guide your clients through these types of conversations as well. So please let me know if that's something that you'd be interested in. But talking about this long-term guardianship, if something happens and the kids aren't 18, who's going to raise those kids until the age of 18? And there's a rubric that judges follow. It's the best interests of the child. And you can see on this page how much information there is. That we're looking at the child's physical, emotional, cultural, spiritual needs, other needs. We're looking at special medical, mental health, development, disability, all these things that the judge has to look for. And especially for us that come from a faith background, it can be really important that our kids are raised in the faith that we believe is so foundational, is the foundational truth that we want them to be raised in. But spiritual matters are such a small part of what the judge is looking at. And it is going to be a crapshoot, depending on which judge you get, how much emphasis they actually put on that spiritual matter. That's why it's so important to get guardianship nominations in place if you have those minor kids. And I understand maybe not everybody here has minor kids, but I just want to share that information with you. There's also the matter of short-term guardianship. So there's long-term guardianship, which is if something happens to you and the other biological parent, who's going to raise the kids until the age of 18. Short-term guardianship is who has the right to stay with the kids in the immediate term if something has happened and you haven't come home from a date night, for example. Does foster care have to get involved? Does Child Protective Services have to get involved? And I know that, I don't want to say anything about Child Protective Services. I think that they do the best job that they can. But I can tell you, again, as a parent of five kids, I don't want my kids spending any time with Child Protective Services. I want them to be in the hands of somebody that we know loves and cares for them. And I see somebody here sharing, I work with immigrant families and would really like to help them understand their options for estate planning, trust, and all. I love that. That's a beautiful sentiment that you're sharing. Thank you. Let's talk about healthcare decisions and who could make healthcare decisions for you if you can't make them for yourself. And the default, we're going to talk about this a lot tonight, that the default, if you haven't taken steps, if you haven't put a plan in place, the default most often is going to be court. That there is some kind of court procedure that exists to decide who gets to make decisions for you and what those decisions look like. From a healthcare perspective, from a decision, about your person perspective, we're talking about a guardianship proceeding here in Minnesota. And there's a story that I tell about this. It's the story of Terri Schiavo, and many of us remember the case of Terri Schiavo. She was a young woman who suffered a cardiac event and was left in a vegetative state. She was on a feeding tube, and her husband decided that Terri wouldn't want to continue on this feeding tube, but her parents wanted her to continue receiving the sustenance. There were arguments about whether or not Terri was reacting to her surroundings. Her parents thought that she was. Her doctors and husband didn't think that she was having any kind of stimulus response. Um, but at the end of the day, this ended up being a series of court cases that went all the way up to the Florida Supreme Court. They even petitioned the United States Supreme Court. But what was eventually decided is that the husband had the right to say Terri's feeding tube was removed, and she ended up passing away about 2 weeks after that decision was made. Um, Terri's situation is a sad one from a lot of perspectives. First off, just the amount of conflict in that family and the amount of court and cost and anger and frustration. And we were all watching it across the United States as well, and developing our own opinions and our own feelings and our own thoughts about what should happen with Terri. If we don't take care of things, then we may be in Terri's shoes. There may be court cases that proceed and continue to scale up until finally an ultimate decision is made. It may not be the decision that we want to have made. We don't know. But the good news is we can decide, and we can decide that information. We can put that information down in a document called a healthcare directive. And a healthcare directive does two things. There are two parts to it. In the first part, you can name agents who can make healthcare decisions for you. And in the second part, you can discuss what kinds of wishes you have for your healthcare. And in particular, there's a great resource that we have available to us called the Catholic Healthcare Directive. It's put out by the Minnesota Catholic Conference. It was actually adopted by the USCCB, the US United States Catholic Conference of Catholic Bishops. I always get that acronym a little goofy, but it was put out by the USCCB, was adopted by the Minnesota Conference of Catholic Bishops and the Minnesota Catholic Conference. But that Catholic Healthcare Directive says some important things. It says that we as Catholics believe that life is a precious gift from God, that we want to receive spiritual support if we're in a time of health crisis, including prayers from our family, from our community, from our church, as well as things like last rites, last confession, viaticum, that type of a thing. The Catholic Healthcare Directive also says that we want to receive ordinary and proportionate care, which means that there is some reasonable hope that that care is going to benefit us, that it's not excessively burdensome, meaning there's not an excessive risk tied to it, there's not an excessive pain, or there's not excessive cost. And also important to note is that extraordinary care, things beyond what's ordinary, can be tried for a time and then stopped. It's not a situation where if you opt into extraordinary care, if you opt into something like a respirator, a full body respirator, something like that, that you have to continue on that respirator forever. But important to know is that certain things need to be provided. Things like medically assisted nutrition and hydration are really important. And the reason for that is that the church teaches we do not starve or dehydrate people to death. And if you take away their nutrition, if you take away their hydration, and you cause their death that way, effectively, that's what you're doing. You're causing their death through starvation or you're causing their death through dehydration, which is sometimes a hard teaching that the case of Terri Schiavo, really was a polarizing case for a lot of us because a lot of us saw her situation and said, I would never want to live in that kind of vegetative state where I couldn't even interact with other people in my surroundings. But the church pretty clearly taught that Terri should have that nutrition and hydration continually provided for her, even if it wasn't going to bring her back to a situation where she had complete conscious understanding of the ability to make her own decisions or complete awareness and ability to interact with her surroundings, that nutrition and hydration was still preserving her life and still should have continued to be provided to Terri Schiavo in the situation that she was in. Catholic Healthcare Directive also says that pain relieving medicine is fine as long as it's not administered for the purpose of hastening our death. And there's a special provision for women who may get pregnant that says if they're pregnant at the time that a decision about life-sustaining treatment is made, then the decision should err towards preserving life in order to preserve the unborn life that's in their womb. So those are things about healthcare. After you have passed on, there are some other important things that need to be talked about, that need to be decided on. And let me tell you, as much as having your legal documents in place is a great relief, I've seen what an immense relief it is for families to have those legal documents well done and well taken care of. Um, uh, Disposition of remains and what happens with the body, what happens with cremation or burial, where that's taken care of, all that is very important and a great relief to people, a great relief to the family if you have it taken care of before you pass away. I see somebody asking, let me back up just a second and talk a little bit more about healthcare because I have a question here. What about dialysis? So somebody says that they had a client's parent that was coding when they attached her to dialysis. And so I guess the question is dialysis ordinary and proportionate care? And unfortunately, I have to give that classic attorney answer. It depends. Um, uh, so dialysis is a processing, it's when the kidneys start to shut down, and it's a way to process the blood and remove impurities so that the person, is that their blood is cleared and that, they're not, um, uh, the blood doesn't become overly uh, gross and unable to do the work that the blood needs to do, which is really oxygenate the body, right? But unfortunately, impurities, things, can build up in that blood and cause problems in the organs and all kinds of things. I should probably have you explain this because it sounds to me like you're a doctor, but I don't want to put you on the spot like that. So, but that's dialysis. So the question is dialysis ordinary and proportionate? And I would say oftentimes dialysis, yes, would probably be ordinary and proportionate, but it depends on, oh, okay, an attorney. Very good. Okay. But it depends on where that person is at in their life cycle. And if they're at a point where they are already coding, oh, and you said client. I'm sorry, I should have I should have picked that up on that as a clue. If that person is already at a point where they're coding, if they're already at a point where life, death is imminent, and they are terminal, then chances are that dialysis may become extraordinary at that point. Again, the analysis is there a reasonable hope for benefit? Even if there is a reasonable hope for benefit, which I think in that situation may be questionable if they're already in a coding situation. Um, is it excessively burdensome? Is it going to be a risky situation? Did the dialysis cause the coding? Is the dialysis associated with increased pain? Is it costly? There's another one here as well. Is it unconscionable? Does the person abhor the idea of their blood being outside their body and purified and then returned into their body? So there are different things that we need to consider, and it's all very fact specific. But I think in some situations, yes, dialysis could be and would be considered extraordinary care. And it may be tried for a time, it may be stopped, it may be denied. Even things like antibiotics could be considered extraordinary in some cases. Certainly one of the things that comes up for me in my practice oftentimes with older folks is they don't want to have CPR performed on them. And we think about that oftentimes if we're younger, we say, well, of course, why wouldn't you want resuscitation done? Why wouldn't you want, CPR done, the chest compressions in order to start your heart beating again in order to continue the blood flowing so that you have your life preserved. But the reality is, the practicality of it is that even if you can have those chest compressions on a 70-year-old or 80-year-old person with osteoporosis that may actually benefit the person. It may actually bring them back from the brink of death. The risks that it can cause, because it causes oftentimes rib breakage. It often causes serious pain to the point where that person is no longer going to be able to function. They're just going to be on massive pain relieving medication that leaves them in an almost comatose state for the remainder of their life. Means that things like CPR can end up being extraordinary care, even though for a 20-year-old, it would be ordinary and proportionate care, that this is something that a 20-year-old should receive. They have a lot of their life ahead of them. There isn't excessive risks of damage. There isn't an excessive pain amount. But again, all these things are very fact dependent. And so I appreciate you bringing that specific case study to me. Again, talking about what we want to have happen with our body after we're gone. Um, Apologies, that's my alarm going off to put the kids to bed. Obviously, we're not doing that here tonight. What happens with our body after we're gone? Well, there's something that's beautiful that can be done called an apostolic blessing. It's a blessing that a priest can give for somebody who is on their deathbed, and it is a plenary indulgence, a complete forgiveness, a complete remuneration of the temporal effects of sin, even that can be given as a final apostolic blessing. The Pope has authorized this apostolic blessing to be given by any priest to somebody whose death is imminent for, and it's a beautiful thing that can be done. We all know about things like last rites and really it's called anointing of the sick, but also things like final confession and viaticum are a final receipt of the Holy Eucharist, of Eucharist before somebody passes away, are beautiful things. And especially again, if you have family members who've kind of fallen away from the church, or maybe they weren't well versed in church teaching and they're not aware of these things can be very important to put into your wishes about how things are handled when you're close to death, excuse me, and then immediately following your death. The church teaches that organ donation can be a great gift, but it has to be done at the right time. And there is some difficulty on this and some difficulty about exactly when that happens and exactly how those gifts are given in a way that preserves the viability of the organ while at the same time not causing the death of the person that the organ is being donated from. How a funeral mass happens. And again, if you have family that's fallen away or family that was never Catholic, make your preferences known if you want to have a funeral mass said for you after you've passed away. The church prefers that your body be there at the mass for a final viewing if possible. And that typically, at least here in Minnesota, requires that embalming is done, depending on how quickly the funeral can be. Um, but it's the church also understands that sometimes the cremation has to occur before the actual funeral mass, and it's not a mortal sin or anything like that to have a person's body cremated before the funeral mass. Cremation is permissible now. It hasn't always been permissible throughout the history of the church, but the church, specifically has said as long as cremation is done in the right way and not in an attempt to defeat the resurrection of the body on the last day, cremation is an okay way to handle remains. But keeping the urn on the mantle is not okay. That we want those remains to be buried in consecrated ground. Gregorian Mass series is something beautiful. If you haven't heard of it before, it's a series of 30 masses that are said in someone's honor after they pass away. And there are great graces that can flow from that Gregorian Mass series. And it can be pretty affordable, especially if you look to some of the missionary priests and ask some of the missionary priests to offer that Gregorian Mass series on your behalf or on behalf of a loved one. Let's talk a little bit more about the assets, about the things that you have. And let's talk about who would receive if something happened to you. And here, at least in the state of Minnesota, I see here somebody asking, can ashes be spread or divided? And the church is pretty clear on that, that ashes should not be spread or divided, that they should be, all of the remains of a person should be kept intact together, even if they're cremated remains. And again, that those cremated remains should be buried somehow, that they should be in consecrated ground in a particular place, not spread over waters or spread at different locations or anything like that. That they should go into ground that has been blessed by a Catholic priest. That's a good question. Um, so again, let's talk about the assets and let's talk about who would receive. And here in the state of Minnesota, at least, I don't know about actually, I feel pretty confident about Texas because I think you guys also have the Uniform Probate Code as well. But typically, there's a pretty common sense procedure here that the state understands that we want our spouse to receive some of the assets, maybe all of the assets, in order to take care of them for the remainder of their life. And that after something happens to our surviving spouse, our kids are the next ones to receive. And in fact, there's a whole scheme for what happens if the kids can't receive, that we look to any descendants that you have, so kids, grandkids, great grandkids, all the way through your line of succession. If it doesn't find anyone there, if it doesn't find a spouse, it doesn't find any kids or anyone, any issue or descendants of yours, it actually goes up to your parents' level and would give the assets to your parents if they're living, or if your parents aren't living, it would give the assets to descendants of your parents. So that's brothers and sisters, nieces and nephews, grandnieces and nephews, great grandnieces and nephews. It would follow that line of succession from your parents. It even goes up above that. It goes up to parents of parents, so grandparents. It goes up to the grandparents level and again flows kind of like a waterfall. It even goes up to great grandparents. There is a point you have to get pretty far advanced. I mean, you can imagine by the time you've exhausted, especially us Catholics, all of our cousins and second cousins and cousins once removed and everything, there is a point where finally the state says, you know what? We have looked for relatives and we haven't found anyone. And now your assets are going to escheat. They're going to go to the state in order to provide for the things that the state needs. But you have to get pretty far advanced before that actually happens. At least that's some good news that I get to give. Um, but important to remember there, or important to hear there, is I talked about a lot of different people who might receive. Certainly we want to make sure that our kids are provided for in some way, or, our spouse first and then our kids are provided for. And maybe we want to provide something to our grandkids, maybe to help them through education, something like that. But what isn't included in that, what isn't included in the intestacy provisions, those are called, the provisions about what happens if you haven't detailed where the assets go, is things like our church and the charities that are really important to us. If you are giving to your church, if you're tithing to the church, or if you're giving in a manner weekly or monthly, if you give to capital campaigns and that kind of a thing during your lifetime, it would be very good for you to be able to continue that kind of a gift if something happens to you, and to be able to give to your church either in a lump sum at your death or through something like an endowment. And there are some great ways that you can give an endowment to your church. There are some great organizations that you can do that through here in Minnesota. And if you have more questions about that, I hope that you'll reach out to me. We also know that there are a lot of great charities that we have. Here in Minnesota, institutions like Pro-Life Across America were founded here. Things like Sharing and Caring Hands. We have some great seminaries here in Minnesota that are fantastic. Obviously, Knights of Columbus, Catholic schools, lots of different charities that we might want to give to, but that would never be naturally included in the gifts that are given from our estate unless we take action and specifically give to those places. Now let's talk more about the how. How does this happen? How is it carried out? And again, the default plan typically is going to be court. If it's for healthcare matters, the court case is called guardianship. If it's for financial matters, the court case is called conservatorship. If it's after your death, the court case is called probate. And all of this is true unless you take action and make something else happen. As you can imagine, whenever there's court, conflict is likely. Court is an adversarial system, and it's designed to put two litigants up against each other to hear their arguments and make decisions for who prevails, who has the right to say. And so you're going to have a son against a daughter, or a nephew against a niece, or a brother against a sister, or a parent against, a sibling. Whatever the case is, you're likely to have some conflict if you haven't done planning. And there could be arguments about things like, well, I know Uncle John would have wanted there to be equal distributions, or no, I know Uncle John would have wanted to take care of me, especially because I took care of him in a special way during the last 2 years of his life. For decisions about guardianship, decisions about your body and your healthcare matters, there could be arguments about should there be a feeding tube, should there not be a feeding tube. Again, it's going to ask these parties to line up and make their best argument about what they think should happen. And it's just a recipe for conflict. So the default after you've passed away here in Minnesota is probate. And probate, a few things happen. Number one, the court names an agent who is going to stand in your shoes and administer your estate for you. And there's already room for conflict if you haven't named who that personal representative is going to be, because the court needs to decide who that person is going to be, and they need to judge based on who is making the application and who wants to be the personal representative. The court is also going to make sure that creditors have been paid. And then finally, after all creditors have been paid, they're going to make sure that any additional assets are distributed out among the heirs or devisees, the beneficiaries of the estate, in the way that is supposed to happen legally. And probate, which you need to know, it takes a long time here in Minnesota to go through the probate process. Oftentimes it's something like 12 to 18 months. It's at least 6 months for sure, but oftentimes it's more like 12 to 18 months. It's also costly, and we estimate here in Minnesota that probate costs something like 3 to 6% of the gross value of the estate. We estimate it that way because it's a good back of the envelope way of estimating what the complexity of probate is likely to be. But probate requires things like paying attorney's fees and filing fees, bond premiums, executor fees, appraisal fees, creditors. It's a web of different fees and slowdowns and processes that cause all these things. So to give you an estimate for what that means, what does 3 to 6% of the gross value of your estate mean? Well, for example, if you own your home and your home has a value of $400,000, a good estimate for probate on the low end here in Minnesota would be something like $12,000. $12,000 to go through the probate process. It's expensive and unnecessary. There are good ways to avoid it, and we'll talk more about that here in a little bit. Probate's also public. So this is the will for our president JFK, our past president JFK. And here I'm able to access his will because it had to be made public. It had to be published with the probate court to detail what was going to happen with his estate. And something interesting here, if you look, it says, I give and bequeath unto my wife, Jacqueline B. Kennedy, if she survives me, the sum of $25,000. It goes on to say that she receives one half of the remainder in addition to that $25,000, in addition to personal effects, tangible personal property. The other half of the property, the other half of the residue, actually ended up going to JFK's children and issue. So Jackie Kennedy didn't receive everything from JFK's estate after he passed away, which is kind of an interesting historical tidbit for you here tonight. The good news is that court is optional. Court is optional. You don't have to go through guardianship for healthcare matters if you get a healthcare directive in place. That healthcare directive can name an agent who can make healthcare decisions for you and can specify your wishes about how your healthcare is handled. It's not necessary for your financial matters or legal matters either, that you can put in place a power of attorney that can name a financial agent who can handle your finances, can handle legal matters, can handle tax matters for you. And again, you can name the powers that you're giving to that agent. Court is also optional after you pass away. But a will is not the way to avoid probate. In fact, we have this really goofy saying as estate planning attorneys, where there is a will, there is a probate. Oh, it makes me groan when I say it, but it's memorable. Where there's a will, there's a probate. And what it means is if you are relying on a will to handle the distribution of your assets at your death, then probate is necessary if you're relying on that will. And that's the key, that you can rely on other tools, on other instruments to transfer your assets in a way that is free from probate. And a couple of great ways to do that. Certainly, there are things like beneficiary designations and transfer on death deeds. Beneficiary designation, many of us know that from things like our life insurance or retirement accounts, that we can name a beneficiary who would automatically receive those assets, those things after we passed away. And those are carried out automatically by matter of contract with the retirement custodian who's holding on to that retirement fund, with the insurance company that has written the insurance policy on your life. You can also put beneficiary designations on things like brokerages and bank accounts. You can even put it on things like savings bonds. A lot of times you can do a transfer on death designation on things like stock, shares of stock. You can even put, here in Minnesota, you can put a transfer on death deed on your home, which acts as a beneficiary designation. So after you pass away, automatically your home will transfer to the people that you want it to transfer to. All of that's possible. And if you have a very, very, very simple estate, those beneficiary designations and transfer on death deeds can be a way to help plan for those assets. But I always tell people if you have more than two kids, I already get pretty reticent to write a transfer on death deed for you. And the reason is a transfer on death deed really does take and transfer the home or whatever real estate you've written that TODD on, the TOD, on to those individuals that you have named as the beneficiaries. And if you have three kids that you've named as beneficiaries of your home, as recipients of your home, all three of those kids need to agree about what's going to happen with the house. Is it going to be sold? Is one of the kids going to move in? Are we going to keep mom and dad's house and rent it out, or are we going to keep it and visit it as a rent as like a vacation property? And I've seen how this happens. I've seen situations where three siblings just couldn't agree, and the house ended up falling into dilapidation, and the windows are broken out, and the door is broken in. Nothing happened, and unfortunately, the house is just a waste at this point. Not only those three have a say in what happens at the house, but also if they're married, here in Minnesota, our spouses have an interest in the real estate that we own. And so now all of a sudden you've got potentially six people who have a say in what is going to happen with the house. And if there's any disagreement there about what's going to happen, if they're not all united in a decision, then everything kind of grinds to a halt and causes problems. Another tool that we have for avoiding probate is something called a revocable living trust. And in a simple matter, a revocable living trust is this. Somebody starts with property and they entrust that property to somebody called a trustee. And they say, here's what I want you to do with that property. And the trustee says, yes, I agree. I will use this property in the way that you have asked me to use it. And that could be for the benefit of the kids. It could be for, whatever situation. The trustee says, yes, I will use it in the way that you asked me to use it. A revocable living trust is a special one because during your lifetime, certainly you're the one who starts with property. You're also the one that you are entrusting the property to, that you are the trustee of your trust during your lifetime. The advantage here from an estate planning perspective is that after you pass away, we can have a successor trustee step into your shoes. They don't have to be approved by a court. Unlike under a will, you actually have to be appointed by the court in order to serve as personal representative or executor. Under a trust, that person automatically becomes the successor trustee at your death. And if you've transferred those assets into the trust already, your successor trustee just gets to pick them up and administer them in the way that you have instructed them to administer those assets. And again, it doesn't have to necessarily be for the benefit of the trustee. It could be for the benefit of your kids. It could be for the benefit of a charity. Whatever you've instructed, told that trustee to do, they have an obligation to carry out those wishes. And so you're able to really easily avoid probate by putting things like your home into the trust through a quitclaim deed. And by going to the bank and transferring the bank accounts into the trust by telling them, I've created a trust, here are the details. I want you to retitle that bank account in the name of my trust. And by doing things like pointing the beneficiary designations for things like retirement accounts and life insurance so that after you pass away, they automatically, by default, get paid into the trust and the trust can administer them in detail where they're supposed to go. Something about estate taxes here, and usually I get to give people good news. And I need to update this. The good news is estate tax isn't going to apply to most of us. That there is a federal estate tax and a Minnesota estate tax, but the federal estate tax doesn't kick in until you get. Now, I had here the exemption 13.99 million. It's actually $15 million now after the recent law has passed here that we don't have to worry about federal estate tax until we get above $15 million. It's a very high number. And if we're married, it's portable, which means that our spouse can use our unused exemption. If they're whoever the surviving spouse is can use the first spouse's exemption. What that really means is you really get about $30 million in estate tax exemption from federal estate taxes. In Minnesota, the exemption is smaller. The exemption is only $3 million. And so it starts to be more of an issue, starts to apply to more people. And it's not portable, meaning you have to preserve the deceased spouse's $3 million exemption when they pass away in order to get a second $3 million exemption when the survivor passes away. And there are some great ways that we can do that, great ways that we can plan for that, but you have to do some planning in order to take advantage of that. This is something that's really important. As Catholics, a lot of times we can be very charitable. We can be very interested in providing for people who maybe have special needs or maybe have some kind of a disability. And I just want to caution you on that if somebody has some kind of a disability and they might be on a government program, leaving them an inheritance can end up knocking them off of that government program, requiring that they spend all of the money that they received in the inheritance and then requalify for the government benefit in order to get back to the standard of living that they were accustomed to from the beginning. So it can be really difficult, really harmful. If you know anybody who has, something like, they're not able to live independently because of issues with autism or Down syndrome, or just other situations where they're not able to live independently and maybe reliant on a government benefit like food or housing or medical care, leaving assets to them in an inheritance can be really harmful, but we have good ways that we can provide for them through something like a special needs trust or supplemental needs trust. So I've talked a lot here tonight, and I've brought you through a lot. And probably something that I've talked about has resonated with you. Maybe it's things like who's going to take care of my kids until the age of 18? I need to get that in place. Or maybe it's things like who's going to make healthcare decisions for me? And I want to make sure that they're making decisions for me that align with my values. Or maybe it's I want to avoid probate and I want to avoid the added cost of probate. Or maybe it's I know that I want to give money to my church and I want to make sure that I put that in my estate plan so that it gets carried out. Whatever the case is, if something here tonight has resonated with you, you're probably thinking, how do I take care of this? And you really have a couple of options. You can try and DIY the situation, you can try and DIY your estate plan, or you can hire an attorney. And I just want to caution you away from DIYing your estate plan. DIYing your estate plan is like trying to put together IKEA furniture without any instructions. It's really complicated. There are a lot of moving pieces and it can go wrong very quickly. And I like to share a story here that happened to me. It's a true story. It's involves fishing, and I had ordered a couple of fishing poles to take my son fishing. He was young; he was like 5 years old, and they got to me without any fishing line on them. Not a problem. I ordered some fishing line and went down to the basement and wound some fishing line onto those rods and reels. And as I finished winding those rods and reels, fishing that fishing line on them, I went to cut the line, and I don't know exactly what I got wrong. If you know what I got wrong, please let me know. But all of a sudden, that fishing line started jumping off of the reel, and I just had this huge tangled mess of fishing line on the table in front of me. I like to tell that story because that was a place that I did a DIY project and I failed. It went wrong, but it was okay. I was able to fix my failure that same morning. I was able to untangle some of the fishing line and really just cut off the rest of it. I lost maybe something like 30 cents worth of fishing line, right? Maybe something like 5 minutes of my time to try and untangle the mess and undo the problem that I had caused. But I was able to take care of it, and I was able to take care of it quickly. DIYing your estate plan and getting it wrong is the exact opposite of that situation. If you get your estate plan wrong, you are not going to be able to fix it. It's going to be up to your family to deal with the consequences of that failure at the time that it's failed. And I can tell you, it's not going to take you them 5 minutes to fix your problem. It's not going to cost 30 cents to fix the problem. I've been on that side. I've taken care of people fixing estate plans, fixing things like transfer on death deeds that were written incorrectly, fixing estate planning documents that were written incorrectly. And unfortunately, it costs thousands of dollars in attorney's fees, leads to conflict in the family, and leads to a level of resentment with the person who has passed away that I know none of you want to face. So, I don't want you to try and DIY your estate plan. Obviously, I'm biased. It's true. But as an estate planning attorney, I want you to come and work with an estate planning attorney. But when you choose an estate planning attorney, I also want you to be choosy. You can either choose a typical estate planning experience, which may not serve you and may not serve your family in the way that you want, or you can write a plan with somebody like me, and I can tell you, I can make sure that that estate plan is written in the right way. So the typical estate planning experience is this, that the typical experience is you're going to be working with somebody who's writing form documents that are kind of set it and forget it documents. Typical experience isn't going to keep your money out of the Minnesota Department of Unclaimed Property. It doesn't create an inventory of your assets. A typical estate planning attorney doesn't make sure that all of your assets are going to transfer to the people that you love and the people that you want that money to go through. Typical experience may avoid probate, but may not. In fact, I've heard estate planning attorneys describe when their practice gets older as their practice maturing, which means now they are helping clients through the probate process that they helped to write the plan originally. To me, that's a failed plan. If you write an estate plan and that estate plan has to be probated later, there are some, I've had a couple of clients who have opted for probate, but typically with most of my clients, we're trying to avoid probate. And it's a failed plan if you are in probate. Typical experience probably isn't going to keep your family out of conflict, especially if that probate case is involved. It may leave assets to heirs unprotected. In fact, it's unlikely that there's any kind of asset protection over those assets if you're working with a typical estate planning attorney. And there's not going to be ongoing legal guidance into the future because there's typically hourly fees that they're charging from the start and for any future needs that you have. And it's probably not going to adequately protect your kids from both long-term guardianship and short-term guardianship. Really, you're going to be left with this question: is my plan going to work when I need it to work? And that's not a question that I want anybody to have, not a question anyone should have after they've worked with an estate planning attorney. Planning with me is totally different. I charge flat fees, I don't charge hourly fees, and you choose the fee, typically somewhere between about $2,500 and $6,000, depending on what you want your plan to look like and what features you want to build into your plan. But the power is really with you. You get to choose the fee that fits you and your family the best. The revocable trust, I know I talked about that as an estate planning tool. I just want to point out that a revocable trust typically does start around 4,500. So if you have questions about fees and that kind of a thing, we'll certainly talk more about that if you want to reach out to me in person. But I just want you to have some of the scope and some of the information about what fees typically are. Planning with me means keeping your money out of the hands of the state, both from the unclaimed property, making sure that your representatives know where to find all of the assets, and making sure that no more needs to go to estate taxes than is absolutely necessary. It's going to protect your kids totally for guardianship in the immediate and the long term. It's going to keep your family out of court and conflict. I am a peacemaker. That's what I come to this conversation with and what's important to me. And so it's very important, I know, to keep your family out of court and conflict, and it's a guiding principle for me. You'll also know that you've made the right decisions because I empower you to make those decisions in the course of our meeting together, and make sure that you have all the tools and all the education and information that you need to make those decisions. Planning with me also means that you can protect the family money from outsiders, things like a divorcing spouse or creditors in a bankruptcy, excuse me. And it means a lifetime of guidance and protection because when you plan with me, that initial fee includes ongoing conversations and guidance about your plan and about the things that matter to you. And here's the most important thing: you are going to know that your plan is going to work when your family needs it to work. And wouldn't that be a great assurance? Wouldn't it be great to not have that weight on your shoulders anymore? So, choosing an attorney, I really encourage you to reach out to me. And I'm going to offer you a meeting with me here in just a minute. I went ahead and shared my link there so that you could see that. Um, I want to make this really easy for you. And so I want to offer you an initial meeting with me. It's a 2 hour long meeting. It has a $750 value called a family wealth planning session. In that session, we talk about the things you have and the people that you love and exactly how you can protect them. We start by talking about where you're at right now and where you want to go. And then we talk about the different estate planning tools that we can use to really bridge that gap and to get you where you want to go with your estate plan. And if you decide to work with me, because the family wealth planning session, again, is free, there's no obligation to continue and write an estate plan. But if you decide to write an estate plan with me, I will give you $250 off the estate planning package of your choice, as long as you reserve your family wealth planning session before the end of the week. And let me just say, if you look at my calendar, if you click through that link that I put in the chat here, tjslawoffice.cliogrow.com/book, if you take a look at that link and you look at my schedule, you're not going to probably find any additional time right now in August. There's no time that can be booked in August. There's probably going to be some selection in September, but it may start to get picked over here during the course of our presentation. That's why it's important that you jump on this now. I'm not expecting that you book your family wealth planning session before and we meet before Saturday. It's not going to happen. And a big reason why is I spend a lot of time with my clients. And so because I spend so much time with my clients, I only take on a select number of clients each month. It's a specific number that I take on, and I really limit the number that I'm taking on just so that I can give them the attention and time that they deserve. But I really want you to click that link, click on Family Wealth Planning Session, and find a time that works for you. And it's okay if you need to check with your spouse. I would recommend actually that you get in and schedule that meeting. Even if you need to check with your spouse, I recommend that you get in and check and get the meeting on the books. And then if we need to adjust the meeting, we can do that. You can call in to my office and and we can always adjust the time that the meeting is. But I really want you to get on my calendar and make sure that that you're moving forward in the best way possible. I do have some questions here. I'm going to leave up some of the things that some of the reviews that I've received and some of what my clients have said, because I do want to ask, or I do want to answer some of the questions here that I'm seeing pop up. And as well, if you have additional questions to this, I really encourage you to bring those at this time. But please take the opportunity here tonight to click on that link, look at my calendar, find a time that's going to work for you. Like I say, even if you have to clarify it with your spouse later, or another, if you want to bring a child to the meeting with you, that's absolutely fine. If you need to clarify the time later and we need to adjust it later, that's just fine. But please get yourself this next step already scheduled with me. So I have here a question from somebody. Does your mortgage company have to be informed or added to your trust? That's a great question. And the answer is no. There's a great law out there called the Garn-St. Germain Act that says as long as a transfer is to a revocable trust and it doesn't change the way that you can reside in the home, then the mortgage company cannot accelerate the mortgage or exercise a due on sale clause for that mortgage. So there's no reason that the mortgage company should have to be informed. Still, sometimes people do choose to inform their mortgage company, and we're able to help them through that process. But honestly, I don't recommend it because the mortgage company often will get confused and say, "Why are you telling us this? Is this something that we need to be worried about?" And then they start to do more due diligence and get their legal team involved, and we just have to finally back them down and say, "Look, Garn-St. Germain Act permits this. Stop bothering my client. Please stop calling them and sending them emails and letters that sound threatening. You're not actually permitted to do anything." And the mortgage company tucks their tail under, between their legs and says, "Oh, sorry, we got this wrong." I see another question here. What is the Minnesota state amount that you can have and not have anything go through probate, i.e., everything has designations on them? Thought it used to be 50,000. Also, would an attorney charge that 3 to 6% on all of the assets, including the designated ones? These are great questions. So, number one, the threshold for probate is actually a little bit higher than 50,000. It's $75,000. So as long as you don't have real estate in your name at your death, and as long as the total assets that you do have in your name don't exceed $75,000, you can avoid probate. And that includes if you're able to put beneficiary designations on things like retirement accounts, life insurance, if you're able to do that transfer on death deed on the home, then potentially you could have your vehicles remain in your personal name at your death. And as long as they don't have a total value of more than $75,000, as long as you don't go out and buy that Cybertruck and leave it in your personal name, then you can avoid probate and have those beneficiary designations. And then the second question is, would an attorney charge that 3 to 6% on all the assets, including the designated ones? Actually, attorneys typically work through probate either on an hourly fee or on a flat fee that is not going to approach that 3 to 6% most often. The 3 to 6% is just an estimate, and it's an estimate of the combination of all of the different fees that might be charged as you go through the probate. It also includes things like running costs on the house, that it typically takes at least 4 months to prepare a house for sale, oftentimes even longer than that through the probate process. And you can imagine that you have real estate taxes, you have homeowners insurance, you have mortgage, you have all these things that continue running and continue needing to be paid, as well as things like filing fees with the court. The personal representative can collect a fee. Certainly, attorney's fees make up a big part of that. Accounting fees, if returns need to be made, all those things are what add up to 3 to 6%. So it's not a perfect number. It's just an estimate that we give of what we expect probate to cost. I also see a question here. Does your state have a Medicare recovery program? I stepped away, so I'm not sure that I stated that. Working with low income, it's often something that we consider, i.e., Todd protects the property from recovery program. And so there we're really talking about estate recovery, that if we have received Medicaid during our life, or here in Minnesota, we call it medical assistance. If we've received medical assistance during our lifetime, the state wants to recover the money that they've paid for that medical assistance from our estate after we're gone. And the answer is yes. Here in Minnesota, we do have estate recovery. And we don't have all the tools that some of the other states like Florida and Texas have that can really help us combat that estate recovery. But there are some good ways that we can do it through things like irrevocable trust that have started to become more available, or through things like there's a process of using Medicaid eligible annuities and some gifting during somebody's life that we engage in order to help with that. But I know, I think you guys have something called a ladybird deed. I could be wrong, that might help you to protect things like the home from that estate recovery process, which is really great. I also see a note here, believe it or not, that is going to be detailed planning for your family is very detailed. So he's offering something great. Oh, thank you very much. I wish that we had the time to even sit with someone to discuss all their options. So if you're still here and if you get a chance to book and you're in his area, get to book from one attorney to the public. I really appreciate that. Thank you very much for that endorsement. We try to be very thorough and we spend a lot of time with our clients. Good. Yeah, you do have the transfer on death deed and the Ladybird deed. Yeah, that Ladybird deed is just fantastic an estate recovery perspective and from a Medicaid eligibility perspective is a great thing. So that's really good. Does the estate plan include taking the beneficiaries through the process when they inherit? That's a really good question. There is a specific amount that we will help with after our clients have passed away. Yes, that we do give the fiduciaries and we give the beneficiaries a runway of assistance so that they can take care of things for the estate and for the trust. Absolutely. And we think that that's really important. We think that that's part of what you're paying for is making sure that there is at least some runway, some help to your loved ones after you're gone. So the answer is yes, there is some help that we provide for that, but there's also a point where that help would exceed what's typical and that runway that we typically give. And so there is a point where we would need once we exceed a certain point to start asking for some compensation for trust administration and estate administration help if it gets to that level. So that's a great question. I may see somebody else saying, "Thank you, I'll be in touch." Fantastic. I'm looking forward to talking with you. So please, next steps here are to book your free family wealth planning session with me. Again, it's a free session, but it has a $750 value because I'm setting aside 2 hours of my time to talk about the specifics of you and your family and to make sure that you know exactly what's going to happen. And I want you to use that $250 discount towards the estate planning package of your choice, just to make it more affordable, just to encourage you to take this next step and to get on my calendar. And I see again another question. Do you retitle the assets with the plan? That's a great question. I do have plan levels where I will take on retitling of your assets for you. I will take on things like beneficiary designations for you. It's really up to you and whether or not you feel comfortable with it. But typically, most of my clients, we provide guidance on how to do that beneficiary designation planning and how we do and how to do the retitling. And we stand as a resource for you if you have any additional questions. But we typically have our clients take on that work, although we do provide an option where you can hire us to be the person who's going to take care of that for you. Yes. So again, I really encourage you to click on the link. I encourage you to find a time for the family wealth planning session in order to take care of things. Another question here, if you only have one child, do you need a trust? And the question again, or the answer again is it depends. It depends on your assets, it depends on the things that you have, it depends on how you want the kids to receive or how you want that child to receive. And we would talk about it. We would talk about it in your meeting, and we would make sure that we were choosing the option that is right for you and is right for your family. Sometimes a trust can still have some benefits. For example, if something happened to your child and you wanted some contingencies in place about where the assets would go, such as the way that they would go to grandkids, or if they would go to charities in that case, or they would go to someone else, it might make sense to write a trust. It depends on the situation. Or if you have assets at different places, and we want to combine them all under the trust to make sure that they're all accessible as quickly as possible, a trust still might be a good tool. But a lot of times, I've certainly written a lot of plans that have been more will-based plans with a lot of beneficiary designation planning and that transfer on death deed for the home in order to make sure that that's cared for. So it really depends on the situation, and I would love to have the opportunity to talk with you more about it in person. I hope you'll take me up on the offer to have a meeting with me. This has been really great. This has been really fun. I appreciate the questions here and I appreciate your attention and your attendance here this evening. You know more about estate planning than you did when you came in, and you know the best next step in order to get a great estate plan written. I encourage you to reach out to me and to meet me for a family wealth planning session. I'm looking very forward to meeting those of you who take me up on the offer. I hope you all have a great evening and a great rest of your week. Take care.